game-changing Madras High Court judgment that just redefined when a clock starts ticking for the GST appeals. This particular judgment of Sri Ramajam Engineering Industries versus the Deputy Commissioner of State. This judgment fundamentally changes how we calculate the appeal timelines when the rectification application are involved here. So let's break down what happened and why it matters, and also how it impacts every GST practitioner and businesses who are going for appeals, right? So in August 2024, this particular SSC receives an assessment order from the Deputy Commissioner of State Tax, right? So what happened? This order lacked proper reasoning and for upholding the particular demand which was in the show cause notice, right? So in November, the company files an rectification application under Section 161 of CGST Act, seeking reconsideration based on their detailed explanation, right? So in November 22, in 4 days, the tax authority rejects the rectification application without providing any good reasons or any reasons, which is a classic bureaucratic dismissal by the authorities, right? We all know that. This created a critical dilemma for the company here. So what if they filed an appeal now? Would the appellate authority start counting the limitation period from the date of original order, that is August 19th, or from the date of November 22, which is the date of rejection of the rectification application? So rather than risking their appeal dismissal on technicality, this assessee took the matter to the Madras High Court and filed a writ petition. This writ petition challenged both the original assessment order and the rejection from the rectification application, right? So what was the core question in here? The core question was that the Madras High Court faced a straightforward yet pivotal question, that when the tax authorities reject your rectification application under the Section 161 of GST Act, so does your timeline to file an appeal that starts running from the original assessment order date, that was in August, or the date when your rectification application was rejected, right? The answer would affect not just this case but potentially thousands of the GST appeals. We all know that because this question still pertains, right? The judgment came in December, but many people does not know the answer of this question. So Justice K. Kumaresh Babu ruled in this judgment and delivered a clarity and decisive terms that the court recognized that Section 161 of the GST allows for rectification of assessment order, which is a process that can end with either acceptance or rejection of the taxpayer application. The court here made a crucial distinction that when the rectification is granted, it merges with the original order, which is a standard practice. But when the rectification is rejected, and here's the breakthrough here, that the limitation period does not revert to the original assessment order. In precise terms, Justice Kumaresh here held that limitation periods begin from the date of rejection of the rectification order, not from the date of original assessment order. And this applies regardless of whether your rectification application succeeds or fails, right? So this particular SSC here, this meant the limitation period start from November 22 and not from the August date, which was the date of original assessment order, right? So the court here explicitly directed that when calculating the limitation period for an appeal after the rectification rejection, the clock starts ticking from the date of rejection of application of the rectification application, right? So why this matters? The judgment here transforms the appeal strategy landscape for the GST assessees nationwide and the practitioners also. Why? Because it eliminates the rectification trap, because many taxpayers no longer have to choose between seeking rectification or preserving their rights to file appeals, right? Now the assessees can confidently pursue the rectification without fear of that the appeal window might close, right? And secondly, it acknowledges businesses that the rectification is often faster and less expensive than a full appeal, right? And businesses should have the right to try this route first without penalty. And thirdly, it creates a procedural certainty by establishing a clear rule that limitation clocks restarts after the rectification decision. The court has eliminated a major gray area in GST litigation, right? So what is the takeaway from this decision here, the Madras High Court decision? The court here has effectively given taxpayers a procedural shield here. Why? Because now you can file a rectification application under section 161 and wait for the tax authority's decision, and if it is rejected, then you can go for a appeal, because the limitation day will start from the date of rejection of the rectification order. This judgment reinforces that using all available remedies under the GST law is your right as a taxpayer. The system cannot penalize you for following their procedures because they have established it. And for the businesses and tax practitioners, tax professionals navigating the GST landscape, and this ruling provides a essential clarity on fundamental procedure issue that affects virtually every disputed assessment case, right? And that's all in this video. So thank you for your attention in this critical development in the GST jurisprudence, right? Because it was a gray area, right? So stay informed, stay compliant, and remember that understanding procedural nuances can be just important as knowing the substantive area of the law, right? Thank you.